Good evening, professionals. Today we are going to talk about one easy and simple topic on formation of business organizations, which is incorporation of societies. So the first corporate law webinar series on formation of business organizations will get concluded today with formation of societies, in which we are going to talk about the various procedures of registration, how to form a society, and the income tax exemptions available to it. So, to give a brief introduction of societies, why societies are formed? Many people, individuals, or corporates, or any form of organization will always like to serve the social purpose, and the social purpose could be best achieved through an unified attempt, and the best way of bringing all people together is by forming a society. So the NBOs or NGOs could be formed in various modes, like Section 8 company under Companies Act 2013, or a trust, or it could also be formed by way of registering societies under Societies Registration Act. The Societies Registration Act is a central act, and also it is governed by under various state acts driven by the respective state government laws. With this brief introduction, let's get into the webinar for today. My sincere thanks to Mr. Sundar Rajan for this detailed presentation on societies formation. This is the outline for today's presentation. We'll be covering the basics on the meaning of society, the examples of various societies registered under Societies Registration Act, types of societies, formation of society, the constitutional document which is required for registration, procedure for registration, what are the benefits if you register the society under Societies Registration Act, documents required for registration, caveats attached to it, other registrations, taxation of society, procedure for registration under Income Tax Act, caveats, and few recent case laws. So let's get into the meaning of relevant terms. Who is a founding member? Subscriber to the Memorandum of Association is the founding member. And there shall be a minimum of 7 founding members for a society. And these founding members, unlike your trust, which we saw last week, where the trustee shall be a resident in India, here a foreigner could also be a founding member, individuals, corporates. So any form of members can be, and they are eligible to be founding members for a society. And what is a governing body? Section 15 of Societies Registration Act and Section 16 of Registration Act define the term member and governing body. If you see who is a member is like your Companies Act. He is a person who contributes to the capital. So a person who subscribes in the form of subscription fee, he is a member. And who is disqualified to be a member? If you see the section, it says that one who has not paid his subscription fee over and above 3 months shall be disqualified to be a member. And if he ceases to be a member, say he is resigning to be a member in accordance with the rules and regulations of the Societies Act, then he shall cease to be a member. So one who enrolls or is in the list of members of the society will be a member. Then the section governing body comes. The governing body is the one which controls the functioning of the society. So they are elected again by the members of the society. The governors, council, directors, committees, trustees, or other body to whom the management of affairs are entrusted. Let's look at the definition of office bearers. So a person who holds an office in the governing body, be it a chairman, president, vice president, treasurer, executive member, or secretary, they will be considered as office bearers in society. What is the meaning of society? If you read the preamble of Societies Registration Act, it says this is an act for registration of literary, scientific, charitable societies. And when you see why this Societies Registration Act was formed, this was formed for the purpose of improving the legal condition of societies which are established for the purpose of literary, scientific, or fine arts, or diffusion of useful knowledge, or diffusion of political education, or charitable purpose. And if you see what is charitable purpose, like section 2 subsection 15 of Income Tax Act 1961, here again charitable purpose or charitable activities are defined under section 20 of Societies Registration Act. And if you see the wider meaning of societies, it is an association of persons united together by a mutual consent. So the unified intent is important, to act jointly for some common purpose. So there shall be some common objective. Unlike any other form of business organization, the objects for which the society is established shall be a lawful object. And the members shall be people who are eligible or entitled to enter into a contract. Again, drawing a reference to your Indian Contract Act 1872. Now let's see the few examples of societies. So Gunj is an NGO formed by Mr. Anshu Gupta during the year 1999. And if you see their vision and mission, this is an NGO engaged in channelizing material as a tool to address the gaps in rural infrastructure, water, environment, livelihood, education, health, disaster relief and rehabilitation. And the interesting fact is, friends, if you see their annual reports, they say that year on year, they've been turning old material as a resource for various rural development activities. And the disaster relief, they consider that as poverty as one of the disasters, and which they are addressing in the form of NGO established in the year 1999. And again, this is a society registered under Societies Registration Act. Helpage India was established in the year 1978. Originally, they were funded by UK, United Kingdom, and Mr. Jackson Cole, as the founding member and the first president, established it as Helpage India here. NGOs, and as the name goes, it is for providing healthcare to disadvantaged elders. Make a Difference is a registered society, again formed during the year 2006. And this is an NGO engaged in providing educational support to children in need of care. And its vision is to enable children in the need of care and protection to realize long-term outcomes equitable with middle class. And if you see their website, what is equitable outcome? They say that it is the reasonable quality of livelihood which is required for each child. So this is equitable outcome which they say. So basically, to provide quality life and also to have that attitude or to save from life threat. So these are important for protection of children is their vision and mission. And these societies are registered under Societies Registration Act. And of course, they are all registered under FCRA also to receive foreign donations. So these are the broad classifications of societies. The society on the basis of registration is classified as registered society and unregistered society. Of course, a registered society will be entitled to income tax exemption, whereas unregistered society will not be entitled to, like your trust, which we saw last week. And also benefits of registration are like opening of bank account, credibility while you receive funds and while you are doing any institutional programs. So all those benefits we will be seeing in the respective slides. Let's see the formation of society now. The prerequisites are minimum of 7 members to form a society, and these are governed by Societies Registration Act Central Act or corresponding enactments governed by respective state governments, if any. Like MP, you have Madhya Pradesh, the respective state Societies Registration Act, and also you have the Cochin Literary, Scientific and Charitable Societies Registration Act 1955, Travancore Act. So the respective states are also governed by their enactments. And society can be formed for the promotion of literature, science, fine arts, or for diffusion of useful knowledge, or for diffusion of political education, or for charitable purpose as provided in Societies Registration Act. Now let's see the constitutional documents like your memorandum and articles for a company, trust deed for trusts. Memorandum and rules and regulations are the constitutional documents for registration of society. And these two are primary documents because the presumptive evidence in the case of company will be your certificate of registration, certificate of incorporation, which will be the conclusive evidence that you are formed as a company. But in the case of societies, if you see the certified copy of your memorandum of association and the rules and regulations shall be the presumptive evidence that you are registered as a society. Hence, these two documents assume significance while you register a society. So, memorandum of association is the legal document which sets out the scope of the society, and the clauses in the memorandum of association are the name of the society, the address, objects of the society. The registered address of the society is not mandated under the act, but it's always better. Like your company, you mentioned the place of establishment to have more transparency. And the name, address, and occupation of governors, council, committees, directors, or other governing body, the definition which we saw in the previous slides. Name, address, and full signature of all the founding members of the society. The rules and regulations. These are for the internal management of the company. So this is a legal document which regulates the functioning of the society, and it binds all the members. Binds because these are the rules in accordance with the provisions of the act, and if the rules are driven in conformity with the provisions of the act, it is valid. If they are contradictory to your provisions in the act, then the act shall prevail like your any other specific act. And these rules form a contract amongst the members of the society, and hence it is binding amongst the members of the society. And generally, the rules and regulations comprises the details of composition of the governing body, which again has your council, directors, committees, details of membership, who are the founding members, and their name, their addresses, all those details, admission fee and subscription fee details, rights and duties of each member, functions and powers of the governing body, powers and duties of your office bearers, this president, vice president, secretary, meetings, legal proceedings, and dissolution. Now let's look into the registration of society. It is optional to register a society, but like your trust, it is beneficial to do so. Why? Because you can claim IT benefits, and you can also get better visibility and reliability amongst the stakeholders. So registration provides legal status to the society. It shall be done under Societies Registration Act or the enactment as per the respective state government's law. In order to avail tax exemption, it is mandatory that you get registered under Income Tax Act. So in order to claim exemption under ITA, you shall make the society registered under the respective state government laws or the central act. Now let's see what are the benefits if you register the society. It enables the society to vest property in its own name. So this is another significant difference between the company and a society. So company and society, the common point is the separate legal entity concept. But there, the property shall vest with the member. But in this case, in the case of society, the property shall vest in its own name, in the name of society. And it facilitates opening of bank account in the name of society. It provides right to sue and be sued, to enforce legal proceedings in the court of law, which is very important. Otherwise, like your unregistered partnership firm, you will be deprived of the benefit of suing and being sued. And it helps the society to obtain registration under Income Tax Act, Foreign Contribution Regulation Act, or any other statutory authorities. It enables the society to raise funds from outsiders and also to institutionalize various programs. Registration will always be helpful. Now, who can register? Section 20 defines the charitable activities which can be done under Societies Registration Act, because the preamble very clearly says that the societies can be registered under literary, scientific, or charitable purpose. So, the charitable societies, military orphan funds, societies established at several presidencies of India, and societies which are established for the promotion of one, science, literature or fine arts for instruction, two, diffusion of useful knowledge or diffusion of political education as mentioned in the preamble of the Act, foundation or maintenance of libraries, reading rooms, public museums, galleries of paintings and other works, basically for for protection of the monuments and other arts, collection of natural history, mechanical and philosophical inventions, instruments or designs. For all these activities, societies can be registered under the Act. The procedure for registration is very simple, unlike your other forms of organization. So you shall ensure that the name is a unique name that you have selected, and it shall not be identical with any existing name and shall not attract the provisions of Emblems and Names Prevention of Improper Use Act 1950 like any other form of business organization. And it's interesting to note, professionals, that the society's word can also include trust. So it will not be a misnomer. So it is not that only trusts which are registered under the Indian Trust Act or the respective laws are required to have the trust as the suffix. Even societies can have trust. Preparation of MOA and rules and regulations of the society. Signature by all the founding members in the Memorandum of Association and by at least 3 office bearers in the rules and regulations. Collate other required documents for submission to Registrar of Society. So before you submit the documents, each state legislation has slightly varied procedural aspect. Hence, it's better that the draft documents are submitted and we seek clarification before the final documents are executed and submitted to them for seeking approval. So, filing all the necessary documents with the Registrar of Societies of the respective state in which the society is formed. So, now let's see what are the documents required for registration. So, as mentioned, the formalities vary from state to state. Applicant, it is suggested that they approach the Registrar of Societies having jurisdiction in the respective state before the documents are submitted to save time and effort. The signed Memorandum of Association of the Society along with certified copy is as provided under Section 3 of the Act. Rules and regulations of the Society duly signed. Covering letter requesting registration of the Society, and there is some requirement in the Act and it's the general practice that it is signed by all the founding members. Affidavit sworn by the President or Secretary of the Society stating relationship between the subscribers. Address proof for the registered office of the Society and NOC from the owner. So if the address is a leased premises and you have entered into a lease agreement, the lease agreement is between the lessor and the lessee, and there is a clause stating that you shall not sublease to any other sister or associate concerns, in which case it's always better that you approach your landlord and say that you are forming a society in the same premises where you already have the business organization, in which case you can seek there no objection and the same shall be attached. A declaration has to be given by the president of the proposed society that he is willing and competent to hold the said post. So he is competent to enter into the contract. So that shall be submitted. The KYC of all the founding members, which shall be your identity and address proof. And the caveats attached to this registration process is signature shall be affixed in all the pages of MOA. So the subscribers or the founding members shall attest in all the pages of MOA. And the signature shall be witnessed and attested in the MOA and also the rules and regulations. And witness shall be an oath commissioner, notary public, gazetted officer, advocate, chartered accountant or a first class magistrate. And now let's see the other registrations required. The society is formed and registered now under Societies Registration Act. What are the other registrations required to receive the contributions, to be entitled for the exemptions are provided under Income Tax Act and also to receive foreign donations? So in order to claim exemption for carrying out charitable activities, it is mandatory that the charitable institution is registered under Section 12A of ITA. Only societies engaged in the services of charitable or religious activities can be registered under this Act. And for foreign donations, it is essential for the society to get registered under Foreign Contribution Regulation Act. Society shall obtain a registration certificate from central government. So societies are taxed under 80A unless they are specifically excluded under Section 11 and 12 of Income Tax Act 1961. The exemption is available to charitable and religious societies, as mentioned in the previous slide, which are registered under Section 12A of Income Tax Act. And societies are considered as artificial judicial person and are taxed similar to individuals. Now let's see the procedure for registration under Income Tax Act. Application in Form 10A shall be filed electronically along with the required attachments like your MOA certified copy, rules and regulations copy, notes on activities to be performed by this society, certified copy of registration of the society. Hence, it is mandatory that you get the society registered under the respective acts. Application shall be digitally verified, signed in case the return of income has to be filed using DSC, or else it shall be verified or signed using electronic verification code. And CIT shall verify all the documents and further seek any clarification on the documents submitted, or further queries can be raised, and the time limit is a maximum of 6 months from the date of submission of application. If the same is not received, any further clarification, or in case of failure by the CIT to pass an order within the 6 months time limit as prescribed under the Act, it is deemed that the registration is granted to the applicant. Now, for the donor to claim benefit under Section 80G of Income Tax Act, what are the requirements we shall see? So, 50% of the donations made under Section 80G, the deductions can be claimed by the donor provided the following conditions are satisfied. 1. The society derives its income, which is exempt under Section 10 subsection 23AA, 10 subsection 23C, 11 and 12 of Income Tax Act, and MOA and rules shall not contain any provision stating that the income or assets of the society shall be transferred or applied for purposes other than charitable use. And the society shall not be formed for the benefit of particular religious community or caste. Society maintains regular books of accounts and maintains the income and expenditure account, and it is registered under Societies Registration Act or the respective state legislation. Society is approved by the Commissioner under Rule 11AA, where application for such approval has to be made in Form 10G. So, Form 10A for your 12AA registration, Form 10G for the deduction available to donors under Section 80G. So, the caveats attached to this are: it is mandatory for the society to be registered under Societies Registration Act or the respective state government enacted law in order to get registered under Income Tax Act. And tax audit is mandatory where the total income exceeds the basic exemption limit of 2.5 lakhs. And tax audit report in Form 10B shall be filed along with the return of income. Like your trust, the same provisions shall apply to societies. Now let's see two interesting case laws before we conclude this session. One is Sanatam Dharam Educational Charitable Society versus CIT Exemptions, Chandigarh. The case is as recent as April 2019 and the other one March 2019. Here, an educational institution carries on activity of education primarily for educating persons. Mere fact that it makes surplus would not lead to a conclusion that it ceases to exist solely for educational purpose. So, if you are going to have a surplus, that does not disqualify the society to get registered under the respective act, is what the judgment says. Provided the surplus shall be used only for the purpose of furtherance of objects, in which case mere fact that the surplus is received by the educational institution does not justify the commissioner to decline the grant of registration. The next case is Saint Wilfred Education Society versus Principal Commissioner of Income Tax, Central Rajasthan. Here, an assessee, being an educational society, had given scholarship to several students and had produced several documents in support of making this scholarship payment, as sought by the Commissioner of Income Tax. Mere non-appearance of certain, but they took a sample of 25 students for verification, and few students gave response and few students could not give the response, and mere non-appearance of certain students for verification cannot be a sole basis to declare that the scholarship payments were not genuine, because the educational institution provided sufficient proof and established the fact that the scholarship payments were made in terms of vouchers and the relevant books of accounts being maintained by the educational institution. Hence, the non-appearance of certain students for verification could not lead to a conclusion that this institution will not be entitled to get registration under 12AA. Hence, this was considered to be genuine, and the withdrawal of registration granted to assessee under section 12AA was considered to be not genuine, because there was sufficient proof for establishing the fact that the scholarship payments were made. And also in the same case, during the time of demonetization, there were several old notes, the cash denominated notes lying in the educational institution. Again, the commissioner CIT held that these notes were held by the educational institution, which was not in contradictory to the provisions of Income Tax Act. But again, the educational institution could produce and substantiate it with the necessary evidence, and hence this particular commissioner was not justified in declining to grant registration of society. Professionals, with this we will conclude this session on formation of society. I'll be glad to take your queries or any clarification pertaining to the subject. With this, we'll be concluding the first webinar series on corporate law relating to formation of societies. From next week, Wednesday, we are going to talk about fundraising in the form of equity and debt. Thank you so much, professionals. Good evening.